Let's talk about J1 visa, two-year home residency requirement or Rule 212E, and how to get a waiver if you are planning on staying with your U.S. citizen partner and pursuing marriage adjustment of status application later on. By the end of this video, you will learn what an advisory opinion is, how to navigate skills list, plus everything you need to know about waivers and timelines. We've helped many couples navigate this exact same journey. Although we don't assist with waivers directly, we help you navigate everything that happens right after, from conditional green card all the way through naturalization. Here's the timeline of the member of our marriage immigration method who had a J1 visa prior to applying for their green card. You can check our full interview with this couple here. Now, let's get to the first thing you need to know. Are you subject to the two-year home residency requirements? Whether you're subject to Rule 212E would depend on the conditions for which your J1 program was granted by your program sponsor. Typically, you would be subject if your program was government funded by either your government or the US, or if you're participating in a medical-based J1 visa program, or if your program involves specialized knowledge that is needed for the development of your home country. You always need to start with looking at the exchange visitor skills list. You also need to check your Form DS 2019, and in the left lower corner, you will be able to see if you're subject or not, and you can check your visa stamp as well. If you aren't sure if you're subject to this rule, or if your visa stamp and DS 2019 have conflicting information, you can request an advisory opinion to be conducted by the U.S. Department of State's Waiver Review Division. During the advisory opinion, your J1 exchange visitor program documents will be reviewed to determine if you are subject to the two-year home country presence requirement. It normally takes 4 to 8 weeks to receive a decision, and you can learn more on the process through the Department of State website, which we've included below. It's important to know that sometimes people believe they aren't subject, but they in fact are. So what happens is that they most of the time would look into their visa stamp, which says they aren't subject. They go ahead and apply for the marriage adjustment of status. From there, they receive an RFE saying that, or request for evidence saying that they're subject, and now they have to go ahead and get the waiver and then apply and pay the filing fees again, since Form I-485 would get denied in this case. If your DS 2019 and visa stamp have conflicting information, you need to know that the USCIS is not bound by visa annotation. So you would always want to start with looking into the skills list. If the subject field code is not listed for the country in question, then you can file to adjust your status, and in that case, the USCIS can make their own determination. Although getting an advisory opinion ahead of time would give you obviously peace of mind. If the code is listed, or if 212E applies based on source of funding, then you need a waiver. So before you do anything, you need to make sure you know whether you are subject to that rule or not, whether that means looking into skills list or even getting an advisory opinion when needed. For the purposes of this video, let's assume that you are subject to this rule, and now you want to pursue a waiver of the two-year home residency requirement, since it is your plan to apply for a marriage adjustment of status afterwards. The first step is to determine if you qualify for a waiver. There are 5 different ways that can make you eligible for a waiver. Number 1 is showing that your departure from the U.S. would cause an exceptional hardship to a U.S. citizen spouse or your green card holder spouse and children. To meet this criteria, you have to go beyond simple physical separation. There has to be more to the story. Just know that physical separation from your family alone does not meet the qualification for exceptional hardship. Now let's talk about persecution. If you can show that by returning to your home country you will face severe persecution due to your religious and political views, you can qualify for a waiver. If you work for a federal agency that deems your work necessary and of national interest to the US government, you can also qualify for it. Maybe you're working on a project for, or a project that is of interest to a US federal government agency, and that agency determines that your contribution and stay in the United States is vital to one of its programs, you can get a waiver. Same with being a medical professional who works for the U.S. health agency in the area of the U.S. that is underserved. If you are a foreign medical school graduate who has an offer of full-time employment at a U.S. state healthcare facility and are working in an area experiencing a designated shortage of healthcare professionals, you might be eligible to apply for a J1 visa waiver. Finally, and this one is a common one, you can receive a no objection statement from your home country, simply saying that they have no objection against you remaining in the U.S. after the completion of your J1 program. This no objection statement must state that your home country has no objection to you not returning to your home country to satisfy the two-year foreign residency requirement, and that you may remain in the United States if you choose to. Without a no objection statement, you must satisfy this two-year foreign residence requirement by returning to your home country. Look, if Beside our marriage immigration method, we work with scholars, trainees, etc. who went ahead and handled their own waiver. And from there, we guided them through their marriage green card, removal of conditions, and naturalization. And although in this video, we will give you an overview of how the waiver process works, you might still want to consult with an attorney to make sure you're on the right track and your waiver is being handled properly. Okay, so after you determine what qualifies you for a waiver, here's how you would normally initiate this process. Step 1 is to complete Form DS-3035 online, which is a J-1 visa waiver recommendation application. We've included the link in the description and it will take you straight to the US Department of State website. The interesting thing is that you will be completing this form online, but from there, you will need to print it out and mail it to the US Department of State. After you complete this form, you will receive a document with a case number and instructions on what you need to mail and how to properly organize it. Keep in mind that the address where you are sending this application will depend on the reason or the basis for the waiver in your particular situation. The most important part from here is providing the supporting documents. Let's say you're applying for a J-1 visa waiver based on no objection statement from your home country. Your home country has to send the no objection statement directly to the US Department of State. It is 100% your responsibility to ensure that the US Department of State receives these documents. If you're applying under exceptional hardship to a US citizen, you will submit Form I-612 to the USCIS and they will then forward the decision to the Waiver Review Division. So you see it changes depending on the situation. From there, you will be checking the status of your application fairly frequently and possibly for months to come. The biggest question is always, okay, so how long will this process take? Keep in mind, you do need to handle this process before applying for a marriage adjustment of status, and it can take anywhere from 8 to 24 weeks. After the Waiver Review Division decides on your request, they will send a copy of their recommendation to the USCIS favoring or opposing your request to waive the 2-year home residency requirement. While the Waiver Review Division is responsible for issuing a recommendation to the USCIS, the final decision on your waiver request, whether to approve or deny your application, is made by the USCIS, meaning you would not have a waiver of your home residency requirement until you receive a notice of approval from the USCIS. And after you receive your approval from the USCIS, you're finally good to apply for a marriage adjustment of status. Do you still have questions about your particular situation? Drop them in the comments. Otherwise, give this video a like and we'll see you next week.